All right, we are talking about intellectual property. So, intellectual property and cyber tech. So, what we're just going to be talking about today are some of the issues that come up about this, and really just some of the background stuff, because this is an area that's even more so than other areas is changing pretty constantly. And so I just want to talk about some of the background key concepts so that then because this stuff is a lot of you are going to be going into computer programming as a career or into IT as a career, and the laws and basically the laws and punishments and everything like that that surrounds intellectual property is a constantly changing area that you will be interacting with. So it's useful to just know some of the general background sorts of things and some of the key issues that arise and will continue to arise in the context of cyber technology and intellectual property. So first off, what on earth is property? What do we mean by property? And I mean this in the loosest sense, not intellectual property, just by like, if you say that's my property, what exactly do you mean?
Something that belongs to me.
Yes, it's about ownership or belonging. And when you're talking about ownership and belonging, when you own something, what does that mean? Like, what rights or what are you allowed to do with something that you own that other people are not? What is it that makes it your owned property?
I mean, you have the right to do whatever you want with that because it belongs to you. So
Exactly. That's the idea. When you own something, you are allowed to do with it whatever you want. And on the flip side, if you do not own something, you are not allowed to do with it whatever you want. So for instance, like my laptop, I own this laptop. If I want, I could smash it right now. It would be dumb of me to do so, but I could do it and there would be no punishment. If, however, I were to break into your house, take your laptop and smash that, because you own that laptop, I have in some sense done something wrong. And so that's the general reason of what property is. And that's really all we're talking about here. It's nothing fancy. Question though, why do we have property? You could have a society in which nobody had any property. Everything was just like there. Everyone would have use of it if they wanted it. And if somebody took something from you, it wasn't yours to begin with. So what is it about property that we like? Why do we have a society that has property and has laws around property? So think about it this way. This generally works better when you actually meet with me in a classroom, because it's not going to apply much very well now because most of you are at home. But when you go out of your house, you take your wallet, but how many of you leave stuff behind in your apartment? You don't take every single thing you own with you. Do you carry everything you own with you when you leave the apartment? No. Why not? Why do you feel okay leaving stuff in your apartment?
because you lock the door,
It's one of it is you locked the door, but there's also an element of, even if you didn't lock the door, or even if you so even if you didn't lock the door, there are certain things you'd still be okay leaving behind. And even if you know that it's theoretically possible to break down the door, or if you live on the second floor, for somebody to climb up the fire escape, why do you still generally feel safe leaving your things in the apartment? Well, if somebody were to get into your apartment and take your stuff, what would happen? Who would get involved and what would they do?
the police would get involved.
Exactly. Yeah, the police would get involved. So there's a legal structure in place to help you get your things back. And so part of the reason why we like property is that it allows us to count on things for certain. If the only way you ever had control over something was to have it in your possession, that you'd have a much smaller amount of things and you wouldn't be able to plan ahead. If the only money you could ever be sure was yours was money that only you knew the location of or that you had in your personal possession, it would be much harder for you to plan ahead. If you forgot where your money was, that would be very risky. So that's really why we liked property. Another element of it is that it feels like there's some sense in which you work for a lot of things, and there's a sense in which if you work for something and you try hard for it, you in some sense deserve to keep that thing. So for instance, if you work hard and they pay you, then there's a sense in which you deserve to have special access to that money. Or if you build something with your own hands, there's some sense in which you've put your sweat and tears into building that thing. You should be able to have rights over it or access to it that others might not necessarily have. So that's really the what property is and the why we have property. And really, some of this stuff is so common sense that we don't even bother thinking why we have property, but that's the general background. So that's property in general. Now, how many people have heard the phrase intellectual property? Has anyone heard this phrase?
Not really, but in the book at least, it's basically like things that it's like more generalized property, or like it's like anything really digital, because it's like copying software of like, oh, say you copied a program or whatever, and then like, is that technically yours, or is it like, and if you give it to somebody, is it technically yours? Because like it's not really like you didn't pay for it or anything, so it's like technically illegal by laws, but it took a while for it to like catch up, I guess.
Yeah, that's where you're actually a couple steps ahead of me, Marcus, but that's spot on. What we're going to be talking about today is in the context of everyday cyber technology. What is intellectual property? And we're going to see it's going to come up in cases of software and computer programs. But generally speaking, what is intellectual property? Well, what is the intellect? If you say you're talking about your intellect, what are you talking about?
Like knowledge, really.
Yeah, it's tied in with knowledge. And where is your knowledge? When you say you know something. So yeah, creative mind. So what we're talking about here with intellectual property is property that has to do with the mind. So these are things that do not exist in the physical world, but rather, in a sense, exist only within a mind. They are what we generally call abstract objects. So there's abstract objects and concrete objects. A concrete object is something you can see or feel or touch or smell. An abstract object is something that you can only access through thought. So examples of abstract objects are, well, what are some examples? What is an example of an abstract object? Something that exists and we can all talk about, but doesn't really, like, you can't see it, you can't touch it.
Happiness.
Happiness would be one. Yeah, happiness. It has sorts of physical things, but you can't see happiness. You can see when someone is happy, but the concept or the idea of happiness doesn't exist in the real world. What are some other ones? God is another one. God is an abstract object. And one of the great mysteries of Christianity is how could an abstract object also at the same time be a concrete person on earth? And so that is one of the great mysteries of Christianity. But God, in the sense of the all-knowing, all-powerful, looking down from above, is an abstract object. You cannot see God, but in some sense, God is an object, or not really an object, but an individual who exists. What are some others? Yeah, your mindset, just like what it is like to have a focused mindset or whatever state you're in at that time. Here's some other ones. What's your favorite song? Or a song you like, or a song you hate. Just somebody give me a song, a pop song, or a rap song, or something that you've listened to on the radio.
Perfect by Simple Plan.
All right, I didn't hear you for a second.
Perfect by Simple Plan.
This is the problem. I have no... Type it out for me so I don't make a complete ass of myself because I don't listen to the radio and I know nothing. I want to use Yaris's because... Perfect. Perfect by... I got the Simple Plan part, but I didn't... Okay, Perfect by Simple Plan. This song here, where does this song exist?
Either could be physical or digital, depending on where you buy it from.
So there's a sense in which it's physical, but also, so you could own a physical, but do you own the song? Like this song here.
Oh no, you don't own it because there's the copyright laws and I think it might be patented, but it's basically mostly copyright laws where like they don't allow you to be like, oh, you physically own it. Um, it's like you're borrowing something, I guess. That's how to explain it. Because a lot of video game companies also do this strategy where like you don't own the actual game. You just it's actually like you're borrowing it from them.
So yeah, let's go with another one, a video game. What is it? What is the song itself? Or what is the video game? Well, it seems like you and I could sing. I mean, if I knew the lyrics and the tune, I could sing this song right now. I could do a recording of this song. Every time Simple Plan has a concert, Simple Plan plays this song. There is this song. However, there's also what we see is the song itself is different from the physical place where that song is saved. So what we have to do here is there is the thing. Let me erase this. The song versus a performance or a recording or a version. So when we're talking about the song itself, what we mean is it's like you and I can own CDs, or we can own MP3s, or we could sing versions of this song, or we could have seen performances, but you can't see the song itself. Because where does the song exist? Well, how was the song created? Who created the song?
Oh, they wrote somebody wrote it with their mind,
Yeah.
and it's like they put it together.
Yes, it's created in the mind of the artist who makes the song. And then what they do is once it's created and it's this abstract thing, like you and I can both think of or sing the lyrics of the song. But then what happens is it can then be brought into the physical world in the form of a performance or a recording or a version of it. So intellectual property is the thing that exists that all these copies are copies of, or these versions are versions of. So the intellectual property is the thing that is created, the thing that is made. And then you can never interact with this directly. The only thing you interact with then is a copy or a performance of it. So any sort of intellectual property, this will include also movies. You can own a copy of a movie, but you individually do not own the movie itself. So who owns the movie? For instance, who owns Avengers?
Disney, and then it goes
Yeah, so it's the Marvel branch of the Disney Corporation. So when we say that Disney owns Avengers, what does that mean? What does it mean to say that Disney owns it?
I think it's like they technically have like all rights to use any
That's
material.
the word. It's a matter of the rights to it. So what it means to own a piece of intellectual property is that you own the rights to it, which means you're the only one who's authorized to create copies of it. You're the only one who's authorized to sell it. And if anyone else wants to buy or sell that thing, or buy or sell a copy of that thing that's not been bought or sold before, they have to get your permission for it. So this is what we mean by intellectual property. These are things like songs, movies, poems, books. You can own a physical copy of a book, but the ownership of the book itself is the person who owns the piece of intellectual property that is associated with that thing. So that's what we're talking about with intellectual property. It's the right to create and copy that thing. So there are another difference between intellectual property and physical property is that with intellectual property, multiple people can own a copy of that thing, but with a particular piece of physical property, only one person can own it at a time. So for instance, Apple has ownership over the intellectual property, the design of the MacBook. So they own, or like the iPhone, they own the iPhone. But then what they can do is sell copies of physical iPhone. So you've got yours, I've got mine, your friend has theirs. So the physical property is owned in a separate way. If you own this, nobody else can own a copy of it. With intellectual property, when a company owns a piece of intellectual property, other people can then own copies of it. So this is not exclusionary in the way that these are. So that's what this non-exclusionary means. So does everyone understand this general idea of intellectual property, of just what it is?
Yeah.
Okay. So why do we care about intellectual property? Why do we include it, and why do we have it in the world? Why is it that we say if you write a song, you own it, or that Disney can say, well, we now own Marvel and we therefore own all the characters? Marcus.
Depending on the like, because people have a different view of property, so like it's kind of like a mix between all of them, where in one sense it's like it's, I forgot what the word was for the, because there's like 3 different types of property or whatever from the different views, like utilitarianism property. But then it's I think it was the creative version. I don't know what the name is, but it's the creative version. And since they put so much work and like their effort into it, I guess I would, how to say it, like, and they created it with their minds, like it's like they own it, and you shouldn't be able to take somebody else's property away, even though like you say like you created it or whatever, and then like nobody else should really have like authority to take that away from you.
Absolutely. So this is the idea, is that if you put your heart and soul into a paper, or you put your heart and soul into a song, and you put that much time into it, there's a sense in which you feel that nobody else should be able to profit off of that. Like it's yours, you own it, it came from your head. Therefore, we need a system in place. Just like if you work hard to build something, you deserve it. Well, if you think hard about something, you deserve it. If you spend 10 years writing a book and then somebody punches you in the face, takes your manuscript and sells it, you would be really unhappy about it because you poured your effort into this thing. It was your work. It is part of you, your creative energies that went into it. So in the same way that with physical property, we like to think that you should get what you deserve, with intellectual property, you should as well. And the flip side of or another reason behind it is this utilitarian point, which is basically the world is generally a better place with intellectual property. The idea is that if we reward, because if you have intellectual rights or the control over something, you can make money off of it. And we want to live in a society in which people can make money off of intellectual property. If Disney couldn't make any money off of Marvel, what would happen to the Marvel universe? Would there ever be another Marvel movie again?
No, because it's all based on profits.
Yeah, exactly. Disney would never make a Marvel movie again. Why is it that the DC universe is not doing as well? And why is it that the Justice League movies 2 and 3 got canceled? Well, it's because they weren't making any money off of it. So intellectual property is a way basically of rewarding artists for coming up with creative ideas, and then rewarding companies for providing those artists with the means to get those ideas out into the world. So the reason we have intellectual property is to make the society we live in. It's basically, if there wasn't intellectual property, nobody would be able to make money off of innovation. And yeah, as Andrew said, intellectual property protection is crucial for innovation. If you couldn't make money off of what you were doing, you would have to find a job doing something else. If you couldn't make money off of creating new songs, nobody would make music except as like a fun side project. You wouldn't have people who could devote their lives to making music that people listen to. And the world would just be, I mean, some people might want to live in a world with no art, no music, no movies, no video games, no books, but most of us would not want to live in that world. but for that world to exist, we need to reward the artists, reward the creative people. And part of what goes into that is having these laws that give people rights over their intellectual or creative property. So that's what intellectual property is, and that's why we have it. So is everyone on board with generally what we're talking about here? About
Yep.
why intellectual property is a thing, why we like it, and why society is better for it. Any questions at this point? All right, so that's the first two. Now, because of this notion of intellectual property, it's a legal notion. It's to have intellectual property is a legal thing where if somebody takes it from you, you can go to a law enforcement organization to get it back. You can take them to court. There's a judicial system around it. There's laws around it. Now, to understand why there's difficulties with cyber technology, we need to understand the main types of laws that exist and that govern intellectual property. So the book itself gets very legalistic, but I'm just going to go with the very basic levels. And there's two main ones we want to talk about. There's a third one, but I'm not going to focus on it today because it doesn't really cause any, actually, yeah, it's almost spring break. It doesn't cause any extra problems. I'll put it up here just for a second. Do people know what a trademark is? It's a type of legal term.
It's like a logo. It's basically like, Rockstar Games has like a trademark with a @R, I think.
Yeah.
And
a trademark is just a little logo or a little phrase that a company has deemed we're the only ones allowed to use this. And if you use this, we get money for it. So things are like the Rockstar Games logo, which if I remember correctly is like an R with like a little star down here or something like that. What are some other ones? Anyone?
Disney's, I think, is also trademarked.
Yeah, basically any classic logo or anything. I can never remember which way it goes, but the Nike sign, the Adidas sign, the NFL logo, any clothing lines logo, any of that stuff is trademarked. And basically what it means is you cannot put a version of that on your own merchandise. If you decide to start a company that you can't use like the New York Yankees logo on knockoff Yankees memorabilia. That's not allowed. The only company allowed to make money off of it is the Yankees. So that's trademarks. They're not as different. They don't really cause special problems in the realm of cyber technology. The two that do are copyrights and patents. So what is a copyright? What is a copyright cover? Anyone know? Have people heard of copyrights before? Typically, the logo for them is this little thing. Yeah. So what is a copyright cover and what does it do? Well, the first thing is, generally speaking, or where have you seen copyrights? What things have you heard are copyrighted?
Anything really big. Yeah, movies, songs, books.
Yeah, basically, things are copyrighted. Yeah, fictional characters. So, for instance, why was it that for years the X-Men could never appear in Marvel movies?
It was copyrighted by a different company, I think. But
Exactly.
it's also a thing with like Spider-Man. It's technically, it was owned by Marvel, but then they sold it off to Sony. And now we have this whole issue of Sony versus Disney.
That's a really great example of it. Where why was it that Spider-Man wasn't in the initial Marvel universe and then he randomly makes an appearance, but now there's all these legal battles? Well, it's because what a copyright is it is the legal right to produce things that are either written or sung or viewed in a movie screen. Basically, what they are things that are perceived by human beings for an artistic sort of reason or for a research-based reason. So these include things like movies, songs, and fictional characters. So what you see is that basically Sony had the right somewhere along the line before Marvel became the big cinematic universe it is. Sony bought from Marvel, the company before they got sold to Disney, just the rights to Spider-Man. So they were making movies with Spider-Man and Spider-Man villains, and they were allowed to, but they didn't have the copyright over other sorts of characters like Iron Man. And so once Disney bought Marvel, and they had all these other characters, what they were trying to do was buy the rights to get Spider-Man back in their, get the copyright for Spider-Man so they could continue making movies involving him. So that's what we mean by copyright, is copyright covers anything generally that can be perceived by human beings and isn't is designed for entertainment or research purposes. What does a patent cover? Anyone know what a patent covers?
Is it like I think it's like something like it's patent, like, so it's like if you create a piece of technology,
Yeah.
and like say the light bulb was patented by somebody, and like whoever owns that has the right to distribute, use, create, and do whatever they want with it for X amount of years.
Yeah.
Most of the time.
So yeah, patents are things that do not cover objects like songs or fictional characters. They rather cover processes and inventions. So they'll cover things like the light bulb or the television or the iPhone. And they can also cover the process of creating something. So if you develop a new sort of method for say you invent like you start a company that designs a new type of or let's go with Tesla. Tesla invented a new way of creating electric cars. They have a new process for this. That process can be patented such that nobody else for a certain period of time is allowed to create electric batteries in the way that Tesla can. Nobody else is allowed to create light bulbs other than whoever has the patent in the particular way that the patent is created. So copyrights are designed to allow people, they are basically designed to stir creativity of artistic things or research papers or nonfiction books, things that provide either information or enjoyment to human beings. Patents are designed to reward people for coming up with new inventions or new ways of doing things that have more practical implications. So copyrights are really for knowledge and patents are for processes and things. So within this, what ends up happening is that copyright is basically you come up with a new idea, you are the only one who's allowed to do anything with that idea. Now, very often, as a matter of fact, you'll reach out to a large company who will help you distribute it. So a musical artist owns the rights to their songs, but then they reach out to a record label. And why do they reach out to a record label and often sell the intellectual rights to that record label? Well, the record label has the ability to turn their ideas into actual recordings that can then be played on the radio and sold. So it ends up being a mutual sort of relationship where the artist gets something, the record company gets something, but once that contract is agreed to, the only people who are allowed to create that are either the person who invented it, or I mean the person who wrote the song or wrote the book, and whichever publisher they got into an agreement with. You aren't allowed to go out and whatever your favorite book is, you aren't allowed to go by hand, copy it out, and then just print out copies and sell to your friends. That's against the law. The only person who's allowed to do that is whoever owns the copyright. So does everyone understand, generally speaking, what copyright is and what it covers?
Yep.
Okay, so then there's two provisions, however, in copyright. So when you're writing a paper for a class, you will sometimes include what in your paper. They go within these.
Quotations or citations.
Yeah, you're allowed to include quotes. You're also allowed to, if you want to make fun of somebody, or you want to make fun of a cartoon character, you're allowed to draw a satirical version of it. So if you wanted to make fun of somebody who, you could draw a cartoon version of, If you think Winnie the Pooh is the dumbest thing ever, you could draw a satirical version of Winnie the Pooh. Cynthia, did you have something you wanted to say? I just saw your little microphone go. I didn't want to cut you off. If not, no worries. So, what is it that allows you to use quotations in your own work? Why are you allowed to do that? Anyone know? I'll give you a clue. It's written right here. So, within copyright law, there's this thing called fair use, which basically says that so long as you're not trying to sell something and not trying to pass it off as your own work and are instead interacting with it in a reasonable, fair sort of way, you are allowed to use parts of the copyrighted work for your own interests. For instance, if you are writing a research paper on Shakespeare, you're allowed to use and talk about Shakespeare's characters as long as you're doing it in a fair way. You couldn't use those characters in your own book, but you could use those characters. You could describe them and cite them. Also, things like you are allowed to quote Cardi B lyrics in your review of Cardi B's new album. You're allowed to talk about why, if you're a news story and you're talking about Cardi B has released a new album, you're allowed to quote it or say what the name of the album is, or even play several seconds of a new song on your news show because you're providing people with information. This is all what's called fair use. And what's the reason behind fair use? Why is this included under copyright law? Why are there certain things you are allowed to do with copyrighted material? Just commonsensically. Why do we want it to be the case that we can use copyrighted material in specific sorts of ways? Well, think about how hard it would be to review a movie if you couldn't actually talk about anything that happened in the movie while you were reviewing it. It just wouldn't work. So there's just like, for copyright to be useful, for it to provide the artists with what they need and for society to benefit from it, there have to be certain things that you're allowed to do with it, like include quotes of it, to use small passages of it. The other thing is that there's this provision of first sale. So when you buy a copy of a movie, or let's go with a book, you go to a store. Imagine that I made you buy a physical textbook for this class. You have to go to the bookstore, you spend $100 on a physical 5th edition textbook. You finish this semester. You never have to look at this book again, only you spent $100 on this book. But your best friend is now taking the class next semester. What can you do with your book?
You could sell it to him.
You could sell it to them. And this is what's called the provision of first sale. And why is it that this is allowed? Well, the idea is that once the thing has been sold once, the new owner of it is allowed to do with it what they want. So if you buy a physical copy, that is now your copy and you're allowed to do with it whatever you want. And this is the way in which physical property and intellectual property are legally made to work together. So we said before at the beginning, you're allowed to do anything you want with a piece of physical property. And I'm allowed to break my own computer. Why? Well, because I own it. And that's despite the fact that the design of this computer is owned by the Apple Corporation. The Apple Corporation owns the copyright, or I guess in this case would be I guess there would be an element of copyright to it and an element of patent to it. So in this case, I am allowed to, or a better case would be, let me find a book. Here's an ugly looking book. I own this copy of the book. I could light it on fire, even though I don't own the copyright. Why? Because it's been sold to me. So that's the idea behind first sale, and that's the idea of fair use. So does this make sense to people? And again, this is kind of stuffy, deep, legalistic talk, but it's useful to know because in the context of cyber technology, it becomes important. It becomes valuable. So any questions at this point? All right. Let me power through patents, just what they are and what you have to do to have a patent. And then we're going to then apply all these ideas of why is this stuff problematic as soon as we get into the cyber realm. So for a patent, to get a patent on something, you can't patent anything in the world. There are only certain types of things you can patent. And in particular, they have to be novel, non-obvious, and useful. So, what does it mean for something to be novel? And I don't mean like a book. I mean novel in an adjective sense.
I think it means like something that isn't like already out there. It's
So
like
the
it's like something
opposite
a new
of
whole.
that.
Oh, is it really? Oh,
Yeah, so novel, you're right on the right idea. It's about whether something's out there, but it's rather that it's not out there. It has to be new. Something is novel if it's new. So for instance, I can't copyright the Bible because the Bible already exists. I couldn't go to a store and be like, here's my copy of the King James Bible. I'm going to call it the King James Bible, and I'd like a copy or a patent on it. Or I guess more accurately, because patents apply to processes, I can't attempt to patent the process by which, like I can't process writing or patent writing. Like I'm not allowed to do that. Why? Well, because it's already out there. People have already invented writing. I can't patent the process by which Ford makes its hybrid cars because that process already exists. What does it mean for something to be non-obvious? Well, when something is obvious, what does that mean?
it's clear. It's clear to see.
Yeah, it's clear to see. So non-obvious just means you can't patent something that is obvious to everyone. You can't patent walking. Why? Well, because every human being generally knows how to walk. So you can't put a patent on that and say, I'm the only one allowed to walk. Lastly, it has to be useful. You can't patent something that has no purpose whatsoever. So like, for instance, you can't patent the unicorn harness for easy ergonomic ways of riding your unicorn. Why? Well, unicorns don't exist, so this has no purpose on Earth. And why these three things are important are going to come up when we turn to the difficulties for cyber. So everyone on board with the legal stuff. We've got copyrights, we've got patents, and then we've got why they are the ways that we protect intellectual property. So general patent copyright. A little copyright symbol. All right. What I want to do for the rest of class, which will go for however long we feel like going, there's a couple things I definitely want to cover, but it probably won't take us that long. I want to talk about now, we've got the idea of what copyright is, we've got the idea of intellectual property. Let's talk now about the problems that arise when we intersect the realm of properties law, copyright, that sort of stuff, and we combine it with cyber technology and modern software. Where do problems arise? Why is there an entire section of this textbook devoted to intellectual property and cyber technology? What are just, and there's no right or wrong answers here, there's just many issues. What are the sorts of issues that come up when we start applying these sorts of concepts to cyber tech? What are some issues you face or things that you can think of?
It's because it's so everything is online now. It's like anybody can access it at the same time. So determining who is like the first to like create something, I guess becomes easier. But at the same time, somebody else could technically claim it, and it's given more ways for like say like the example of copyright. It's you could pirate CD, the movies, whatever it is, because the computer the disc itself was easier to copy before, but now they made it harder because now the data is actually harder to break into.
Yeah. But it's still much, much easier. So there's a couple things that Marcus just touched on. One is it's now practically harder because so much gets done on the internet. It can be much more practically difficult to know who actually created something, because as soon as it's created on the internet, it is being created on a computer by an individual. But if you're using a programming language that you didn't create, so it just gets much messier to know who created something. Also, because it's not a physical thing you're working on in your house, but something online, it's going to be connected to a network, which is going to be hosted by somebody. It's much messier as to who owns it. Another major issue, though, is that it's so much easier to create copies of things that it's become really, really complicated to control who is actually making copies of it. So it's difficult to prove that something is being created by you. Yeah, that's another issue, is like, if you're writing a book, you've got a physical copy at your house that you're writing down on. But now, if you're working in digital space, it's in some sense much harder to prove that you came up with it yourself, because other people may have interacted with it. And in many cases, unless you can prove that like it's in a secure network, it's hard to say you were the one who did it, because it's just going to be a saved computer file. What are the implications for how much easier it is to make copies? What are the legal implications and the practical ones? Why is the fact that it's easier to make copies so relevant?
Now you're technically going into the property of like, oh, do you really own this property? Because if somebody makes copies because they bought that property, right? Do you really, if somebody else buys that copy, do they really own that? Or is it like, this is just like not like theirs technically?
So here's Control-C, Control-V. So here's the major issue. When I have a book, if I were to take this book and give it to you, I could give you a copy of this book, and now you would have the book and I no longer would. If I wanted to make it the case that I owned a copy of this physical book and you did, I would literally have to go through and copy every word onto physical pieces of paper and give it to you. Therefore, things like, if I owned a copy, I would have to give it up to give it to you. So it was very hard to get a copy of this piece of work that didn't get it from the publisher themselves. And if the publisher had it, it was far more difficult for anyone else to mass produce those things and undercut whoever has the copyright of it. Nowadays, though, because you can just Control-C, Control-V something, it is so easy to create copies that it is now possible for the owners of the copyright to be undercut and lose out on the profits from regular everyday sorts of people. Like, it used to be the case that, why was it that well, where is the main battleground in this topic? What type of artists or what type of performers or creators are the ones who most commonly are talked about in this fight, this issue of it's so easy to copy and create new versions of something? Anyone know? Like, what area of the artistic community is the one that is most often involved in legal battles over this type of thing? Music. Yes, music is the answer. So one of the major battles that goes on these days, which never was a problem, like 50 years ago, this was not a problem at all. Why was it the case that musicians weren't worried about copying of their music? Well, because outside of, like, back when things were on records, it was very difficult to make a copy of a record. You had to own a record press machine. And the only people who had access to that were record companies. When the cassette tape came along, it started to change a little bit because people could copy cassettes, but it was happening on such a smaller scale that it didn't really matter. Then CDs came along, those became a little bit easier, but then the MP3 came along and it became a major problem, because all of a sudden you could get music from other people much more easily than you ever could before, and you could get it in huge quantities. And nowadays it's even more of an issue, because where's the main battleground right now? What is the main type of way that most of us get our music? How many of you have bought a CD within the past 20 years? Nobody buys CDs. How many of you actually bought an MP3? Nobody does that either. How do we get it? Well, YouTube is one. What's the other big one? What's the other way? Spotify. So Spotify and YouTube are really the main ways people get their music. And it's mainly just in terms of, we stream our music now. We never actually get access to it. So there's this major issue here around the legality of it, where because it was so easy to copy, what ended up happening is these organizations came in that basically said, let's make it so you don't even have to copy our music. You just access our database where the copies of the music are stored, and you can listen to it anywhere. And so there was there's a big to-do of how much are these companies paying the musicians and are they paying them enough? And because there's this big back and forth of, if you're a big time musician, if you want your music to be heard, you need to be on these streaming services. But also, these streaming services, there's a question of, are you getting paid as much as you are worth? Because these days, a musical artist is making considerably less from CD revenue and things like that than they used to. And these days, does anyone know the main way that musicians make their money now? I mean, as of, well, not really right now, but as of like 3 years ago, the main way. It used to be in terms of record sales and things like that. But these days, what's the main way that musicians make money?
View count.
Concerts and any sort of merchandise around a concert. So these days, there's been a major shift in music from like 20 years ago, where 20 years ago, the main way was you just like tour after an album came out, and then you'd go to the studio and perfect your album because that's where you made the money. Nowadays, you have to be touring constantly because that's the main way to make money. And this is why COVID for the music industry has been a bigger issue than in a lot of other areas. And while certain people are perfectly able to continue because they're Taylor Swift and able to make albums at home and still make money off of it, smaller bands and smaller organizations are really suffering, or smaller artists are really suffering from COVID because they rely so heavily on concerts for their money. So that's one major thing, this ability to copy. What are some other areas that you can think of in terms of cyber technology and affecting these things? Some of them are related to things we talked about last week. Others are totally new. So if anyone has one, feel free to shout it out. Otherwise, I can just talk about this software one. So this is one I want to talk about, which is software. So what is software? Describe what software is. Many of you are programmers.
It's basically it's basically programs created by people, and it's supposed to do something.
Yeah, so it's a program, and it's a program that does something. So it is a process in a certain way. So it's a program that does something. It is essentially instructions on a process. It is instructions on how something gets done. It's basically something that is literally like a creative thing. It tells your computer how to create or do a certain process. And we said before, there's two types of laws. There's the ones that govern things that are written, and the ones that govern processes and creative things. So for in a certain sense, given this definition of patents versus copyrights, which one does a computer program or software seem to fall under? If we're saying that patents deal with processes, copyright deals with written ideas, well, which one does it seem to fall under? Well, it seems at first glance that we're going to put software under the patents, because software is literally a process, a way of doing something. However, how many of you have done computer programming before? Come on, I know that I know at least some of you are there.
Yeah, I've done some.
Yeah, currently, some of you are doing this stuff currently. So when you are programming, how do you describe what you're doing? What are the terms we use when you're programming? What is something like C++ or Python?
It's basically the program code, like what you use it on that was already created.
It's a code, or what's another word? A language. It is a language. What is language used for? Well, it's used for writing and saying things. It's the sort of thing that carries information and an idea. It's a thing that has a certain form. So when we think about it from a linguistic sense, where a string of lines in Python is, or a line of Python is in some sense a sentence of Python, and something in sentence or something that is written by a human mind, what does that fall under? What is that sort of creative writing process? That's copyright. It seems like what we have then with software is software as its nature falls halfway between patents and copyrights. It's a type of thing which didn't exist when when law was created, and it falls halfway between the two of them and creates problems for both. So what we find nowadays is that some software falls under patent law, some software falls under copyright law, some things get both patented and copyrighted, and we start to have these legal problems because what this allows for is when we attempt to apply either the patent law, which says that things have to be novel or non-obvious, with the with software, or copyright law, which says that you have a right to first sale and fair use, we also have problems with software. So just to give an example, let's talk about fair use and software. Why does fair use in software lead to a problem? Well, what did we say you were allowed to do with fair use? Use quotes. So you're allowed to quote something in your own work. So you're allowed to say, as the great Abe Lincoln once said, yada, 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 yada. So that is perfectly allowed by fair use. However, what is the worry about using quotes in software? If you quote somebody else's line in a program, if we think of programming as creating a written passage, which is basically how it feels when you're writing it, what is the problem of including a quote in your own coding? Another way of putting this is, what would it be to include a quote in your code?
Um,
The fact that you're all having, so one thing, there's no way to give credit, but more importantly, is there, what would it be if you actually put the code in quotes? It's not going to do anything because it's like not being part of the program. So the moment you try to use the code or put it inside your own code, what are you doing? Are you actually quoting it, or are you just using it?
you use using it.
Yeah, you're just using it. If you include a quote in a computer line, there's no way to really use quotes. The notion of a quote doesn't carry over to computer software. So if somebody puts a copyright on a particular type of, like a set line of code saying like, we wrote this, we worked hard, then there's this problem of there's no way to really fair use it because you can't put it in quotes. You can't do anything. To include any part of that is just to put it in your own code and in some sense steal it. But there's this big issue where anyone who's done any coding knows there's so many things where just like when you're actually coding, you just take little bits and pieces from what other people have done. And really, at the end of the day, because it's a process, there are only a certain limited number of things you could possibly do here. So if you're trying to do a particular programming task, you're trying to run a loop or something, there's only a certain number of ways you can do it. So if you were to give somebody a copyright on something very basic in programming, and because you can't fair use programming, it just seems like you're giving the person with a copyright way too much control over what they're doing. So it seems like on the one hand, if you've come up with a brilliant program, you should get rewarded for it. But on the other hand, there's a problem of figuring out like what justification does somebody have to get a copyright for a program when any other programmer would accomplish a similar task in a similar way. So does everyone understand this issue here with copyright? It doesn't seem to apply nicely to any sort of coding in a computer language. It seems like there's no way of using it without just taking it. So if somebody has a right over it, if you want them to be rewarded for their programming, you want to make sure that they can make the money off of it. However, if you start saying you can't use this idea because somebody else has already written it, well then, if that's a very common sort of programming, like lines of programming code or something that'll be useful in many different areas, it's going to give whoever wrote that code way too much power. So do you understand just the legal like issue here?
Yeah, it's kind of quite ugly with all the
Yeah.
vision.
And the main idea here is like, I'm not going to be able to give you any answers on this stuff, but this is like a major issue that comes up again and again. And if you're doing any programming, there are worries around this sort of stuff, where if you start doing things in a way that is similar to how somebody else has done it, there can be major copyright and patent law sorts of things. And this is one of the reasons why so many companies are so hesitant to allow anybody else to see what their code looks like. Because in theory, anyone else could take it and then it could be used in their own programming. Marcus.
I think it was what is it? Like a lot of the companies now have apparently the I forgot what it's called, but it's basically like something in the contract or what they agree to is like, oh, you can't work on a project similar to like what you've worked on at the company.
Exactly. That's a good thing to bring up. And the worry here is, does that give the company too much power? Is the fact that, like, if you work for one video game design company and they start treating you like crap and you're like, I want to go somewhere else, I want to work for some other company. The fact that they have such careful control over their own programs, does that mean that you're going to be prevented from working elsewhere? Is it going to be harder to get a job within the same field? And in a lot of cases it is, because of these sorts of non-compete clauses that are in contracts.
Yeah, it's usually a couple years. I forgot what it was because like I know some of them like people say that it's a couple years, but other times it could be lifetime, like your whole lifetime that you can't work for another or you can't compete with the company.
Yeah, and Matthew says this sounds terrible, but the fact of the matter is most companies these days have some type, or at least try to have some type of non-competes in their in your contract agreeing, or in your severance contract. So it'll be the sort of thing where they say, all right, we have to fire you, and if you leave, you have to agree, if you want to get your payment for leaving, like, we will pay your salary for 3 months. But if you do that, you have to not work for this other company for 12 months or until yada yada. And very often, there are major legal battles around this right now. So whether or not non-competes should be allowed in contracts, it's different from state to state. So I'm pretty sure Colorado does not allow non-competes in their contracts. And California, it's up in the air. There's a big fight, but it literally does, because of the nature of these sorts of languages and the fact that it is so easy in principle to take something from one programming language and apply it, like carry it over, use it in a new way in a different, or you used it on one program, now you're working on another program, and because the task you have to accomplish is similar, use a similar line of code. Well, because the company's worried about that and worried about losing their proprietary information and their edge on their competitors, they will include these sorts of non-competes. And part of the reason why tech companies do this is because of the nature around patent and copyright. Another issue that comes up with software and patents is just that we said that to get a patent on something, it has to be novel and non-obvious. Well, one of the issues here is that in some sense, whenever you're programming, all you're doing is just like thinking creatively about how to accomplish a certain small task. And so in some sense, every step in a program is obvious to anyone who understands what the task is. Like, if you know that you need to add 1 to solve this problem, then in some sense, every step along the way is obvious to anyone who knows how to program. And because of that, it seems like lines of code are in some sense not really liable to patents because they're all obvious, or at least this argument has been made. But on the flip side, it seems like somebody should be rewarded if they invent a brand new computer game that's never been developed before. Even if every step along the way, every little bit is obvious, it might be that the whole overall program is not obvious. So it's hard to decide, like, should a program be liable to be patented or should it not? And so that's another major issue around this sort of thing, is patent doesn't really seem to nicely play with software either. Again, if you're not following the details of this, that's totally fine. The main takeaway is just that the laws don't line up with the technology itself. Here's another issue. Who would be knowledgeable enough to identify whether some new computer program is so similar to another that it should be considered the person? So imagine, here we go. We have a word processing program, word processor. Let's call it word processor 1. And we have word processor 2. This one comes out, and then a year later, this comes out. The company who owns this one says, this company copied us. we think that they shouldn't be allowed to sell their program. They should not be allowed to do this. We think this is illegal. We want them pulled off the market. Who is qualified to decide whether these two things are similar enough? Who would be able to tell whether this is so similar to this that it should be considered a version of the same program?
Wait, sorry, can you repeat that?
Okay, so imagine a fictional situation. Chris has it. So, but yeah, imagine a situation. We have one word processing program comes out. A year later, another word processing program comes out. The company who made the first one sues the second one for copyright violation. They say this company stole our code. The other company says, no, we didn't. Our code is different from their code. It is significantly different. Who's going to be able to tell who's right? Who's going to be able to tell whether they really are very similar or not? Well, Chris says
Yeah, it's
the answer,
programmers.
it's programmers. The only people who are going to be able to tell are programmers. Now, who, however, is in charge, legally speaking, of deciding on this sort of process?
Supreme Court.
A court is. Now, again, we talked about this a few classes ago. Who is involved in the court? Who are the ones deciding? Describe the people. They start
Judges
with
and
it.
jury.
Yeah, judges and juries.
Everyday, like more like people who aren't professionals in the field.
Yeah, if you're a professional in the law, you are not a computer programming whiz. And if you're a computer programming whiz, you aren't going to be on the Supreme Court. The people on the Supreme Court are old people who, still have monitors that are this thick and use the email sometimes and have never heard of a VPN. So there's this other practical issue of there's just this legal space where we don't really know how to decide on this. And the people in charge of deciding on the law and writing new laws don't have the knowledge to know what's important and whether two things really are similar or not. Another issue is first sale. So when I buy a book, we said the company no longer has any control over this book. I buy a copy of it. Now it's mine. They can't do anything. What's different with a software program, especially like a clear case is in video games? If you buy a copy of a video game, what does that entail? Can nobody in any way affect your video game anymore? Or if you buy any other sort of program, or you buy a new operating system.
Yeah, the company puts updates, I guess. Like they can either make it paid or free, right? And with the operating system, most of the time it's just free.
Yeah, basically there's a major difference between modern technology and a book. With my book, it's not like the authors of this book can decide, like, you know what, we didn't like the things on page 17 and just like magically do something and my book would change. This is a physical thing. They can't change it. With a program, because of the nature of the internet, if they decide to change the program by updating it, they can. So in a certain sense, there's no longer anything of first sale because you are not allowed now to do whatever you want with a program. When I buy my iPhone, I'm not allowed to jailbreak this iPhone, go inside, figure out how it works. Compare that with, 50 years ago, if I bought a car, I was allowed to do anything I wanted to that car. Nowadays, though, in some sense, first sale, because of the nature of cyber technology, has gone away because the company that created it always has the ability to update and access that piece of technology. And this leads to major problems of like, I should, as a consumer, if I buy something, I should have a right to do with it what I want. However, the company is going to say the nature of technology is different, such that because of the interconnectedness, you can never really own anything. And we wouldn't want you to, because that's unfair to the way our business model works and the need we have to ensure that these programs are kept up to date. Like, we need to have access to that so we can update it. And it's not fair if you, the consumer, get complete control over it, because then on top of that, it's so easy to make copies that you could then benefit from making copies of this program. So what we see is just this incredibly messy situation in which the modern pieces of technology that exist do not fit nicely under any of the laws that came before. And what we have is just this absolute chaotic mess. So if you go into programming, know that you are going to be striding into this messy area, that there are many questions and not many answers. All right. I think a lot of you are mentally checked out or off doing other things in your mind right now. I have nothing else I wanted to say at this point other than just generally, this is the takeaway. Intellectual property is a mess, and know that it's very likely that you are accidentally breaking the law whenever you're doing any sort of copying of anything online, and just know that it is a major messy gray area. Does anyone have any final questions on this stuff? Comments, concerns, feelings?
Nope.
All right. In that case, I'm just going to say, have a great spring break. Stay safe. I will see you all in 2 weeks. If any of you got an extension on the paper, and just get it to me whenever I said the extension is by. If any of you forgot that you had a paper due yesterday, get it to me ASAP. And I will see everybody in 2 weeks' time. Again, stay safe, stay healthy, and have a really fun break. And enjoy not seeing my face. All right,
All right,
have a
take
good
care.
one, everybody.
Thank you for
Have a nice
Professor.
break,
The other
Professor.
week.